This is crazy, this is crazy, this is crazy.
Today let's talk about 7 things you need to be aware of within 10 days of your Greenbelt Laurel DUI. Let's assume you were pulled over for a DUI, you took the test, you signed what's called a DR-15, your Advice of Rights form. You were advised of your rights, you signed the form, you took the test, and let's also assume you blew below a .15. Under those circumstances, you are entitled to what's called an MVA hearing. An MVA hearing you would like to have because that would enable you not to have your license suspended for the mandatory 45 days. You're pulled over, you can be suspended for 45 days. It also can be modified. Number 1, it can be modified within 10 days of when you are arrested. There's a 3-part form. You send the form into NVA with your check for $125 requesting an MVA hearing. Number 2, you can send it in within 30 days. If you do that, there is no guarantee you will get that hearing before your license is suspended. You will ultimately have a hearing. Number 3, at the hearing, you will argue, or your lawyer will argue for you, that the suspension should be modified for the purposes of work, if you're working, for the purposes of education, if you're going to school, or for the purpose of alcohol treatment, if you're in any alcohol treatment. Number 4, it is imperative that after the MVA, after you're pulled over, and after hopefully you've seen a lawyer, you enroll in some alcohol treatment. It works to your benefit in both forums. The one forum with MVA, because that enables the hearing, the administrative law judge, to say, look, there is one more reason why your license can be modified. It also works to the benefit of you when you go to court because it shows you did something, you took it seriously, and you are ultimately labeled, hopefully, just a social drinker, and you go through some classes, and you complete the classes, and it looks to the court and to the citizens of Maryland that you are not going to do this thing again. There are issues before the administrative law judge. Mainly the issues are simple. You don't have to speak. They are solely related to the fact, do you have reasons? Is it a necessity for you to use your car? With respect to what goes on before the district court judge, in neither case, by the way, do you actually have to speak. The district court judge are you a risk to do this again? Did you take it seriously? Are you remorseful? Assuming that this is not an aggravated first-time DUI, in other words, there was no accident, nobody was hurt, you weren't speeding excessively. Under those circumstances in Maryland, you will get what's called a probation before judgment.
This is crazy, this is crazy, this is crazy.